In a striking development that has sparked nationwide debate, a federal judge has once again drawn a clear boundary between civil authority and military power in the United States. Though federal law strictly prohibits the use of the military for domestic law enforcement, the president does retain a unique constitutional authority, the power to deploy troops in defense of federal property and personnel, if he determines that civil unrest has reached a level threatening rebellion or hindering the enforcement of federal law. This controversy re-emerged after the Trump administration announced plans to federalize National Guard troops in Oregon, citing ongoing unrest in Portland. However, U.S. District Judge Karin Immergut ruled against the administration's move, stating that the situation on the ground simply did not meet the constitutional threshold required to justify such an action. The administration is expected to appeal Immergut's ruling to the Ninth Circuit Court of Appeals, the same court that previously restored Trump's ability to call up the National Guard in Los Angeles. That earlier decision came after a San Francisco judge had halted the deployment. But in this case, Immergut emphasized that the Portland protests were far less intense than those in Los Angeles and did not pose a significant threat to federal authority or safety. She further warned that accepting the administration's arguments could dangerously blur the line between civil governance and military intervention, something that would ultimately harm the nation's democratic framework. According to Immergut's findings, while protests against ICE facilities had surged in June, they had largely subsided after June 25th. By late September, most demonstrations involved only a handful of participants, typically fewer than 20, and even the larger gatherings were effectively managed by local police, who coordinated closely with multiple law enforcement agencies to maintain order. Still, the Trump administration insists that the president's determination of federal incapacity to enforce immigration laws deserves broad judicial deference. Justice Department Attorney Eric Hamilton argued that isolated incidents of violence in September justified invoking the president's authority, and pointed out that the number of National Guard troops proposed for Oregon was significantly smaller than those deployed in Los Angeles, implying a lighter federal footprint. Judge Immergut acknowledged that presidential decisions on such matters are entitled to substantial respect, but she stressed that deference does not mean disregarding reality. In her words, a great level of deference is not equivalent to ignoring the facts on the ground. This case once again underscores the delicate balance between federal power and states' rights, a tension that has defined the American system since its founding. As the appeal moves forward, the question remains, where should the line be drawn between necessary national protection and the preservation of civil liberty? Before you go, make sure to subscribe to InsightPulse for more in-depth coverage, powerful analysis, and real-time updates on stories shaping America and the world. Your support helps us bring truth, clarity, and insight to every headline.